Sheriff's Department. Open the door now.
Do you have a warrant? I'm an attorney. I know my rights.
We have authority under an active investigation.
Open this door or we're coming in.
I'm a United States citizen. Show me a warrant or leave my property.
At 9:17 a.m., in a quiet suburban cul-de-sac, the sound that split the morning wasn't a siren. It was wood cracking under force. A front door gave way while neighbors stood frozen behind curtains. Inside that house lived a constitutional lawyer, someone who knew warrants by heart, who taught others their limits. Outside stood a sheriff who believed limits were optional. By noon, the damage was done. By nightfall, the county's future had changed. This is not just a story about a raid. It's about power tested in daylight and what happens when the law meets someone who refuses to flinch. Stay with this story. The details matter. The consequences last. The morning had the clean, exposed feeling that only daylight brings. At 9:12 a.m., the cul-de-sac was already awake, mail trucks idling, a jobber cutting between driveways, the low hum of lawn equipment somewhere down the block. Sunlight sat evenly across the street, flattening shadows, leaving nowhere for movement to hide. Inside the house at number 14, the windows were open just enough to let in air and sound. A constitutional law textbook lay open on the dining table, spine cracked from use, margins marked in pencil. A laptop chimed softly as a calendar reminder blinked to life. The man inside had structured his mornings the same way for years. Coffee first, notes second. He liked order because the law depended on it. Outside, order was arriving too, but of a different kind. 2 county vehicles turned in without urgency. No lights, no sirens, just engines easing into place like they belonged there. A third followed, parking a half-car length behind the first. Doors opened. Boots touched pavement. Radios murmured in clipped codes that meant nothing to anyone without training. The deputies moved with the practiced stillness of people who assumed compliance before asking for it. There was no knock. At 9:17 a.m., the front door shattered inward under a single strike. The sound wasn't cinematic. It was blunt. Wood split along the frame, screws tearing loose, the lock failing last. Inside, the lawyer stood frozen, coffee still in his hand, heat rising from the cup he hadn't yet tasted. For half a second, he thought it was a mistake. Neighbors, wrong address, a training exercise gone astray. Then he saw the weapons, then the voices. Sheriff's office, hands where we can see them. The tone was procedural, almost bored. Authority without heat. He raised his hands immediately, coffee spilling across the hardwood floor, dark liquid spreading toward the baseboards. His first words were not defiant. They were precise. "Who's your supervisor on scene?" No answer. The deputies fanned out. One moving toward the hallway, another sweeping the living room, a third positioning himself near the broken door. Body cameras were already recording, red indicators blinking steadily, time-stamping every movement. Somewhere, a dispatcher logged the entry as service of investigation, a category broad enough to hide behind later. Outside, a neighbor stepped onto her porch, phone already in hand. Across the street, a man paused mid-walk, his dog tugging at the leash. Ears pricked at the sudden noise. Curtains shifted. Daylight made witnesses of everyone. The sheriff entered last. He didn't rush. He didn't raise his voice. His badge caught the sun just enough to flash as he crossed the threshold. He surveyed the room like it was already his. The lawyer turned his head slightly, careful not to make any movement that could be misread. "Sheriff," he said steady, "I'm asking you directly. Do you have a warrant?" The question landed in the space between them and stayed there. In the training manual, the answer was supposed to come before the door broke. Probable cause had to be articulated. Exigent circumstances had to be real, immediate, documented. Knock and announce wasn't optional, it was policy. Drilled into deputies from the academy onward, the sheriff exhaled through his nose, a sound barely audible over the radio chatter. "We're conducting an investigation," he said. "Not a lie." Not an answer. The lawyer nodded once. "Then you're in my home unlawfully." For the first time, one of the deputies hesitated. It was subtle, a fraction of a second too long before adjusting his stance, but the camera caught it. So did the light. Daylight has a way of recording things before anyone thinks to. The sheriff's jaw tightened. Outside, more phones were up now, somewhere down the block. A child asked why the police were breaking a door. Inside, the lawyer lowered his hands just enough to gesture toward the splintered frame. There was no knock, he said quietly. No one contradicted him. The morning kept moving. The sun didn't shift. The radios didn't stop, and in that still, exposed light, a line had already been crossed, one that couldn't be stepped back over. By 9:26 a.m., the street no longer belonged to the people who lived there. It had become a perimeter, soft, informal, but unmistakable. Two deputies stood near the curb, not blocking traffic, just existing in a way that suggested movement would be noticed. The muted county vehicles sat with engines running, heat shimmering above their hoods, radios breathing in low, constant bursts. No sirens, no urgency, just presence. Inside the house, the air had changed, not louder, tighter. The lawyer stood near the dining table now, hands visible, posture neutral, every movement deliberate. He knew the choreography, knew how quickly a misunderstanding could be manufactured. One deputy hovered a few steps behind him, close enough to remind him who controlled distance. Another stood near the hallway, pretending to watch the doors while actually watching the man. The sheriff positioned himself near the center of the room, close enough to dominate it without touching anything. He spoke calmly, the way supervisors are taught to when they want compliance without escalation. "Let's keep this simple," he said. The lawyer met his eyes. "Then show me the paperwork." Silence followed, not empty, but calculated. The sheriff glanced briefly toward one of the deputies, a look so small it could have been missed if the cameras weren't already rolling. In departmental hierarchy, this was the moment where justification usually appeared. A folded document, a phone screen, something tangible. Nothing came. "We don't need a warrant under these circumstances," the sheriff said finally. The lawyer didn't raise his voice. He didn't argue broadly. He narrowed the frame. "Exigent circumstances require an immediate threat to life or evidence," he said. "What is the emergency?" A deputy shifted his weight. Another cleared his throat. Over the radio, dispatch asked for a status update. The response was delayed by 2 seconds too many. "Sir," the sheriff said, tone flattening, "this isn't a debate." "That's where you're wrong," the lawyer replied. "This is exactly a debate. It's just happening on camera." Outside, the neighbor's phone caught the broken door, the sheriff's silhouette framed in daylight. Across the street, a man whispered, "Isn't that illegal?" No one answered him. The deputies began a cursory sweep. Drawers opened, a door checked, a closet glanced into. It wasn't a search meant to find anything. It was motion designed to justify presence. Every action was small, defensible in isolation, damning in sequence. Body cameras recorded timestamps. 9:31, 9:34, each minute stacked quietly against them. The lawyer spoke again, softer now. "I want your badge number and your supervisor's name." "I am the supervisor," the sheriff said. That landed harder than any shout. Authority without paper. Rank without restraint. In the academy, deputies are taught that leadership carries responsibility, that unlawful orders must be questioned. In practice, questioning a sheriff in his own county was a career-ending move. One deputy avoided eye contact. Another kept his gaze fixed straight ahead, jaw clenched. Training manuals would later be entered into evidence pages highlighting warrant requirements, sections underlined in yellow. But in this moment, policy lived only in memory. "Am I being detained?" the lawyer asked. The sheriff paused. "Not long, just long enough. Not at this time." "Then I'm asking you to leave." The room held its breath. The sheriff didn't move. Instead, he stepped closer, lowering his voice. "You don't get to dictate how this goes." The lawyer nodded once, as if confirming something for himself. "Then neither do you." Outside, a county cruiser eased to a stop at the end of the street, reinforcing a perimeter that no one had formally ordered. Daylight reflected off windshields, off badges, off lenses that would later be slowed down frame by frame. The power imbalance was no longer theoretical. It was documented. And somewhere, in a quiet office miles away, A server was already storing the footage that would decide everything by early afternoon. The house had emptied of uniforms, but not of consequence. The deputies left in the same unhurried way they arrived, engines idling, doors closing softly, as if restraint could undo intrusion. The broken frame remained. Sunlight poured through the splintered doorway, illuminating dust disturbed by boots that no longer stood there. Inside, the lawyer moved slowly, not from shock, but from calculation. Every step now belonged to a future audience. At 1:04 p.m., he sent his first email. It wasn't emotional. It was indexed. Subject lines referenced timestamps. Attachments were labeled by minute and camera angle. He requested all body camera footage under the state's public records statute, citing the exact subsection that triggered a 21-day response deadline. He CC'd the county attorney, internal affairs, and the civilian oversight liaison, an office few residents knew existed, but one that had to be notified when force or entry occur without arrest. Across town, in a fluorescent-lit administrative wing, those emails landed with, "Wait." An internal affairs lieutenant paused mid-scroll. He had seen complaints before, most unraveled quickly. This one didn't. It came pre-organized, already anticipating the defenses it would face. The footage arrived in batches. On the first playback, no one spoke. The room watched the door splinter inward, watched the lawyer raise his hands before being told to, watched the sheriff enter without urgency or explanation. A training supervisor rewound the clip twice, then opened the policy manual on her desk. The section on knock and announce sat exactly where she remembered it. There were no exceptions that fit. Meanwhile, the sheriff gave a statement of his own. It was careful. He cited community safety concerns, a phrase broad enough to sound responsible and vague enough to resist disproof. He mentioned intelligence that never appeared in writing. He did not mention the warrant because there was none to mention. The lawyer filed the civil complaint on day 12. It named names. It cited case law, Supreme Court rulings on unreasonable search, state appellate decisions on supervisory liability. It included still frames from the body cameras, time-stamped and annotated, arrows pointing to the absence of exigency. The damages section was not dramatic. It was mathematical: property loss, emotional distress, constitutional violation, punitive exposure. The county's risk management department flagged the number immediately. 7 figures was not uncommon. What followed wasn't panic. It was protocol. Outside counsel was retained. Communications drafted statements that said nothing. The matter is under review. The county takes constitutional rights seriously. Inside conference rooms, seriousness took another form. Budget officers ran projections. Training directors pulled attendance logs. One deputy's file showed he'd missed his last legal update seminar due to overtime staffing shortages. Another had signed the policy acknowledgement without reading it standard. Practice, technically compliant, now painfully visible. The lawyer returned to his home office and recorded his own notes, not for court, but for memory. He spoke quietly into his phone, documenting tone, posture, pauses. He described the moment the sheriff stepped closer, described the silence that followed the warrant question. These weren't emotions. They were observations. Judges trusted observations. When the county attorney finally called, it was after sunset. His voice was measured, practiced in containment. "We're looking into this," he said. "You already know what you'll find," the lawyer replied. Another pause. Longer this time. Settlement discussions were floated, then withdrawn. The sheriff refused to acknowledge wrongdoing. His position was institutional as much as personal. Admission would ripple upward, outward, expensive in ways money couldn't cover. Public records requests began to surface in local newsrooms. Headlines stayed cautious at first. Sheriff's office investigated over home entry. Warrant questions raised. Each article linked to the same still image, a front door broken in daylight. The record was no longer internal, and as it grew email by email, clip by clip, it became clear this was no longer about one morning. It was about whether authority could exist without paper, and how much daylight it could survive. Deposition room was smaller than people expect. No flags, No raised seals, just a long table, water pitchers sweating under fluorescent light, and a court reporter whose fingers never stopped moving. Daylight filtered through vertical blinds, slicing the room into pale stripes that shifted as the afternoon wore on. Everything here was designed to be ordinary. That was the point. The sheriff arrived first. Uniform pressed, badge polished. He chose the chair with his back to the wall, posture straight, hands folded as if waiting for inspection. Outside the room, his counsel whispered final reminders. Answer only what's asked. Pause. Before responding, don't speculate. Training for this existed too, though it was never called training. When the lawyer entered, there was no acknowledgement between them. No nod. No recognition of the house they'd both stood in weeks earlier. The record didn't require memory, it required language. The oath was administered at 10:03 a.m. The court reporter marked the time. Sheriff. The lawyer began, voice calm, almost conversational, on the morning of May 14th. Did you possess a judicially signed warrant authorizing entry into my home? The sheriff inhaled, exhaled. No? One word? Plain. Unavoidable. Did any deputy on scene possess such a warrant? No. Did you believe one was required? The sheriff shifted slightly. Based on the information available at the time, I believed exigent circumstances applied. The lawyer didn't challenge the belief. He challenged the foundation. What was the emergency? The sheriff described it carefully, an anonymous tip. Concern for potential destruction of evidence. A perceived risk that could not be articulated without sounding like speculation. As he spoke, the lawyer slid a document across the table. A training bulletin issued 2 years prior, signed by the sheriff himself, outlining exigent entry thresholds in clear language. Does this document reflect your department's policy? The lawyer asked. Yes. And does it require an immediate, articulable threat? Yes. The pause that followed wasn't dramatic. It was procedural, the kind that let a record breathe. Deputies testified next, one by one, each voice different, each memory slightly misaligned. One admitted he felt uneasy but followed orders. Another said he assumed paperwork existed somewhere else. A third acknowledged he never heard a knock because there wasn't one to hear. When asked why he didn't object, the deputy shrugged almost imperceptibly. He's the sheriff. Plain language. Heavy consequence. Outside the room, public interest had sharpened. Local outlet requested transcripts. A state civil rights group filed an amicus brief citing supervisory overreach. The county's insurer recalculated exposure and quietly raised its reserve. By the fourth deposition, the tone shifted. Defense counsel began asking about resolution, not apology. Resolution. The lawyer listened without reacting. He had learned long ago that institutions negotiate only when language corners them. In a later session, the sheriff was asked one final question. Would you do anything differently today? He hesitated. Just enough. I would document more thoroughly, he said. Not regret, not acknowledgement. Process. The court reporter typed the words exactly as spoken. When the depositions concluded, no one shook hands. The blinds were drawn fully open now. Daylight flooding the room, washing it clean of secrecy. Outside, life moved on cars passing, people unaware that policy was being rewritten sentence by sentence inside. Settlement talks resumed the following week. This time, the number was higher. The county commission meeting was scheduled for 2 p.m., the hour chosen deliberately. Midday ensured attendance. It ensured press. It ensured that whatever happened would unfold under the same clear light that had exposed everything else. The agenda listed the item plainly civil liability settlement authorization, but everyone in the room knew what it meant. The projection screen hummed to life. Numbers appeared without decoration. $10,500,000. No gasp followed. Just the low rustle of paper, the sound of chairs adjusting. The figure had been circulating privately for weeks. What mattered now was that it was public. The county attorney stood, jacket buttoned, voice measured. The settlement reflects constitutional violations substantiated by video evidence and sworn testimony, he said. It mitigates further financial exposure. He did not say wrong. He did not say unlawful. Institutions rarely do. A commissioner asked whether insurance would cover it. The answer was partial. Another asked about disciplinary action. The response was careful internal review ongoing, personnel matters confidential. The questions weren't naive, they were ritual. Accountability in public settings, moves in increments. Outside the chamber, the lawyer stood near a window, hands folded, watching the street below. He had declined to sit at the table. He wasn't here to argue. He had already done that in filings, in transcripts, in footage that no one could unsee. What remained was consequence. When the vote came, it was unanimous. The gavel fell once, softly. Policy changes followed faster than anyone expected. Mandatory warrant verification was added to supervisory checklists. Body camera audits were expanded, with random monthly reviews instead of complaint-triggered ones. Training hours on constitutional entry doubled. No longer optional makeups, but prerequisites for promotion. The language in the manual was rewritten not to sound tougher, but to leave less room for interpretation. The sheriff held a press conference 3 days later. Daylight again. He stood at a podium set, slightly too low, shouldered, squared, voice steady. "We respect the court process," he said, "and we are committed to continuous improvement." He did not take questions. Inside the department, the change was quieter but sharper. Deputies talked. Some with relief, some with resentment, a few with regret they hadn't spoken sooner. One transferred out within the month. Another requested reassignment to avoid supervisory track altogether. Authority, once unquestioned, now came with visible cost. The lawyer returned home the same evening. The settlement cleared escrow. The new door fit cleanly into the frame, paint matched carefully, damage erased with professional precision. It looked better than before. That bothered him more than he expected. He stood for a moment with his hand on the knob, listening. The house was quiet. No radios, no boots. Just the hum of the refrigerator and the distant sound of traffic. He stepped inside and closed the door, testing the lock once, then twice. The money did not feel like victory. It felt like evidence. He donated a portion to a legal defense fund that trained young attorneys to take civil rights cases most firms avoided. He paid contractors. He archived the case files, labeling the box simply with the date. He returned to work the next morning. In county offices, the settlement became shorthand, before the daylight case and after the daylight case. New supervisors referenced it without naming it. "Remember what happened," they'd say. And everyone did. Trust did not return quickly. It never does. But something else took its place: hesitation. A pause before entry. A second look at a checklist. A question asked upward instead of swallowed. None of it dramatic, all of it measurable. On the anniversary of the raid, a local paper ran a brief retrospective. No photos this time. Just a reminder of the reforms still in effect. The comment section was quieter than usual. Daylight has that effect. It doesn't shout. It doesn't punish directly. It reveals and then it waits. And in this case, it left behind a ledger of policies changed. Budgets cut, careers altered, and a single truth made expensive enough to remember. Authority survives darkness, but it is always accountable in the light.